I'm Liz McGill. I'm the Dean of the Stanford Law School, and I'm just delighted to welcome you to the 4th Annual FutureLaw Conference. We're so proud and thrilled to be a part of this conference, and so happy to see that every year it grows. Let me start first with thanks. Events like this do not happen without a lot of vision and a lot of execution. So I want to first recognize Roland Vogel, who just asked you to take your seats. The director of Codex, the Stanford Center for Legal Informatics, whose vision and capacity to make this happen has been critical to this occurring in the first place and growing over the years. I also want to thank the Stanford Center on the Legal Profession that has also offered a lot of support to this conference, and the generous support of Thomson Reuters for sponsorship of the conference. This conference is essential, I think, to promoting the exchange of ideas from different corners of the tech world, from large companies to fledgling startups to research universities to governments. The ideas you're going to be discussing today have the potential to transform a whole range of things: legal analysis, criminal justice, government service, to highlight just a few, and to highlight one near and dear to all of our hearts: the potential to make real progress on access to justice. As a legal educator, I can tell you that I feel increasingly an urgent need to make sure that our students are keeping pace and being properly educated about the rapidly evolving world of legal technology, that they understand how it can and will and already has transformed the way we practice law. That fluency is going to make them better lawyers, but it's also going to make them leaders in the profession. So I'm so happy you're here. I know it's going to be a productive day. I'm thrilled that Stanford is a part of this conference and that it's growing every year. So let me turn it over to Roland, who's done so much to make this happen.
All right, well, welcome everyone. Thank you all for coming from near places as well as far places. It's an exciting day of conversations that we have coming today. So we have an amazing lineup of experts from a variety of fields, both actually on the panel as well as in the audience. We have people who've been shaping the discourse in legal technology for a number of years. We also have really some newcomers to the field who bring new ideas on how the law can be improved through information technology. At Codex, we see it as part of our role to really bring together the people who are in a position to advance the legal tech agenda, from within industry, within academia, legal practice, as well as government. So this conference is really our main effort to promote this exchange of ideas and hopefully to push forward the legal innovation agenda. So we have a full day ahead of us. Jim Sandman, the president of the Legal Services Corporation, will open the conference with his keynote titled The Technology Revolution, Lawyers and Courts, Why So Slow and How Can We Accelerate Change? That will be followed by a first panel discussion. Hot or Not, Watson and Beyond, where we will learn about the state of the art, and we'll have a panel that will sort of mercilessly cut through the hype in this area. That will be followed by a brief talk by LegalZoom's Eddie Hartman, who will explain to us how the UK ABS structures work and how they can really help accelerate innovation in the delivery of legal services. And then the second panel discussion in the morning is our computational law update. That's all about the state of the art in legal automation. So then we'll break for lunch. We have a short lunch break at 12:30, and then at 1:10, we'll have our grand unveiling of our legal tech database that we created, which is mapping the legal technology landscape. It's a project that was started by students, and now it's ready for prime time. And we'll also be launching a new publication that's covering the legal innovation space that we are publishing together with Thomson Reuters. So be sure to be here for that launch of this new, I think, very useful resource. And then this will immediately be followed by the Moot Court 2020. So imagine it's the year 2020 and a disgruntled attorney will bring a lawsuit against the entire legal tech industry. So we'll have a moot court session on that, which should be, I think, very, very entertaining. Then we'll break into our afternoon sessions, our breakout sessions, which will happen over in our law school building. So it's just a short walk from here, sort of on the other side of the law school. And our late afternoon plenary sessions will again occur in this room on the role of technologists in reforming the criminal justice system, and a closing session will be on the latest advances in e-government. And then we'll all break for a reception and have some fun. So thank you to everyone who helped put together this conference. Special thanks goes to my colleague Nicole Shanahan, our residential codex fellow, and of course Professor Mike Schnezeret from the computer science department, and the entire program group here at the law school, Trish Girdrich, Jackie Del Barrio, Jody Carey, and Cassie Limchenko, Maria O'Neill have really worked tirelessly to, bring us all together here today. Okay, so I will now turn it over briefly to Nicole, who will explain to us our VR experience. We have virtual reality experience we have prepared for you. So.
Hi, welcome, and I'm very excited to share with you all a virtual reality courtroom experience during the breaks and at lunchtime. You can find the table out in the lobby here, and there is a Google Cardboard for each and every one of you. The reason why we thought VR might be interesting to explore in the context of the legal system is that there's several things VR can provide society potentially. One VR producer said that VR is the ultimate empathy machine. And so we encourage this community to really think about it in terms of applications to criminal justice in regards to reducing bias and presenting fair and accurate evidence, and as well as policymaking, bringing legislators kind of closer to the people that their policies impact. So just right outside here, and I hope you guys enjoy it.
All right, thank you, Nicole. So I'll now be turning it over to Jim Sandman, the president of the Legal Services Corporation. Jim has been a leader of the access to justice movement in this country. The Codex's motto is empowerment, legal empowerment through information technology. So I could not think of anyone better to kick off our conference today than Jim Sandman. So please join me in welcome Jim Sandman. Thank you.
Good morning. I'm Jim Sandman. Please call me Jim, or you can just call me Sandman. A lot of people just call me Sandman. I prefer not to be called Mr. Sandman. You know why? It's the song, Mr. Sandman. Whereas just plain Sandman is more like the Metallica song, Enter Sandman, much cooler. My name is Sandman, not Sanders, but I came here to urge a revolution. And I want to tell you why. I think we have a legal system today that is not working for huge numbers of people and doesn't work particularly well even for people who can afford to pay. My perspective on these issues today is driven from my position as president of the Legal Services Corporation, which is the country's single largest funder of civil legal aid programs for low-income people. We were created by an act of Congress in 1974. We get all of our money from an annual congressional appropriation. We fund 134 independent legal aid programs that serve every county in every state and the territories. No matter where you are in the United States, there's an LSC-funded legal aid program providing assistance to low-income people. I have a perspective on how the legal system is working today for people who can't afford to pay, and it's not pretty. But I have a different perspective from my prior life in the law. I spent 30 years in a big law firm, Arnold & Porter. I served as the firm's managing partner for 10 years. I've had rich clients. I've represented corporate America, and I know how the system works for them, and it is inefficient and too expensive. Technology is a part of the solution. But here we are, 25, maybe 30 years into the injection of technology into law, and how much has really changed? I say 30 years because it was 30 years ago this year that a young associate named Brad Smith went to work at Covington & Burling in Washington. Brad is now president and chief legal officer of Microsoft. Before he accepted his offer at Covington, he insisted as a condition of his acceptance that they provide him with a PC. 1986, he was the first lawyer at Covington & Burling to get a PC. They gave it to him, and he went to the firm, and the rest is history. But has the practice of law really changed that much over the last 30 years? It looks pretty 20th century to me, notwithstanding all of the innovation in technology. And the reason is because the pace of adoption is not what it needs to be. Let me give you some statistics for how this plays out for low-income people. Studies across the United States at the state and local level consistently show that only 20% of the civil legal needs of low-income people are met. Studies of what's called the turnaway rate at legal aid programs, the percentage of people who get turned away with no service of any kind because the resources aren't available to help them, range from 50% to 2/3. And those numbers vastly understate the extent of unmet need. A turnaway rate captures only those people who self-identified their problem as a legal problem, knew where to go to help, to a legal aid office, and got turned and were eligible for service, financially eligible, which today means for an individual an income of no more than $15,000, or for a family of 4, no more than $30,000. And they got turned away. That number does not count people who did not self-identify their problem as a legal one, who did not know where to go for help, who may have known where to go for help but didn't bother because they'd been before and turned away, or because the word on the street was it's a waste of time. And it doesn't capture all of the people who are by no means rich but don't meet the income eligibility standards for legal aid and can't possibly afford a lawyer. The result is that our courts across the United States are overwhelmed with unrepresented litigants. It is common in housing courts across the country, in landlord-tenant courts, for more than 90% of tenants facing eviction to have no lawyer, even though more than 90% of landlords do. It is common in family law cases across the country for the vast majority of people to pursue child custody cases, child support cases without a lawyer. There are family court judges who will tell you that it is the rare day that they see a lawyer in their courtroom. The situation is so dire that victims of domestic violence seeking protection orders often have to go it alone. Think about that. It takes courage for a victim of domestic violence to make the decision to seek protection. That decision itself could put her at further risk. What if he finds out before she gets the order? So imagine the victim of domestic violence who screws up her courage to go to her local legal aid office to seek help, and she gets turned away because intake is closed. And she confronts the decision of whether she should have to go to court alone. If she does, she may confront her abuser there, and her abuser may have a lawyer if he controls the family finances and can afford to pay for one. I have yet to meet the person who thinks that's justice, but it happens every day across our country. I think there are many things we can do to improve this situation, and technology plays a critical role. It's not sufficient in and of itself, but it can help. Why, in the face of a system that is so inefficient, has the pace of adoption been so slow? We have a system that was designed largely by lawyers for lawyers, constructed at every turn on the assumption that you have a lawyer. It was designed with the notion that the end user is the lawyer, not the client. Well, if you look at what's going on in courts across the country today with so many unrepresented litigants, that's a fiction. You would never design the system in the way it was designed if you knew what we know now, that huge numbers of people will have to navigate this system on their own. So I thought a lot about why the pace of change has been so slow. And what I'd like to do this morning is to identify 10 impediments to the adoption of technology and law. And then, so as not to be completely negative, I will identify 10 levers of power, agents of change, that we should try to engage to accelerate the pace of adoption so that 5 years from now we can say that the situation is very different from what it looks like in 2016. So let's start with the 10 impediments. The first is an obvious one. It is a regulatory system, a lawyer-administered regulatory system that is often more protective of lawyers than of consumers, despite protestations to the contrary. It is conservative, slow to act and react, and casts a pall of uncertainty over the possibility of change that deters investment. Let me give you 2 illustrations of how slow the regulatory system is to react. It wasn't until 1999 that the Ethics Committee of the American Bar Association issued an opinion blessing the use of unencrypted email to communicate with clients. 1999. That was a critically important issue. Do you breach the obligation to maintain client confidences by using unencrypted email? It had been going on for years, but it wasn't until 1999 until the ABA could get out an opinion saying that that's okay. Guess what year it was when the ABA Ethics Committee issued its first comprehensive opinion on attorney websites? 2010. This is not a regulatory system that is going to encourage entrepreneurs to spend a lot of money taking chances. A second impediment to the adoption of technology is a judicial system that, because of the federal nature of our government, disperses authority and decision-making across many levels of courts and makes it very difficult to do things if you're dealing with litigation on a national basis. This dispersion of authority is particularly problematic in jurisdictions that do not have a unified court system, by which I mean the state Supreme Court does not have the authority to regulate how lower courts do their business. That is a phenomenon that's quite common in states that have elected judges, where each judge is a king or queen in his or her own courtroom and is not responsible for the administration of that courtroom to a higher judicial authority. It is a particular barrier when it comes to the implementation of standardized forms, a development that is really critical to automation if you're going to try to make it easier for people to navigate the system by helping them to complete court-approved forms. There are states where there are different forms in use in every county in the state, and there are counties where there are different forms in use in every different courtroom, because that's the way judges prefer to deal with it. Well, when you have an innovation like document assembly applications that work like TurboTax, that lead a user through a plain language interview and based on the answers to the questions, complete a form that can be filed with a court, you can't do that if there isn't a court-approved form. If the document that results is something that a judge is going to reject because it doesn't meet his or her individual requirements. A third impediment to the adoption of technology is insufficient capital to support innovation at scale. One obvious reason for that is the regulatory prohibition on non-lawyer ownership of law firms. That poses an immediate and very significant limitation on the funds that are available. Court systems are underfunded. Legal aid programs are underfunded. The Legal Services Corporation does have a technology grant program. And over the course of the past 16 years, it has funded a number of wonderful improvements in technology to serve low-income people. But guess what the appropriation for it is? $4 million a year. A year. And big law firms, who you would think would have the money and the interest, the resources to fund innovation to serve their clients, don't do it. Why? It's because of their economic model, their partnership model where net income is compensation, where the focus is on profits per partner, current year earnings. That deters capital investment of the type that you really need to spur dramatic adoption and innovation in technology. Fourth, we have a pricing model that does not reward efficiency and actually penalizes it. For all the talk about alternative fee arrangements being adopted by lawyers and law firms, the fact remains today that the billable hour is still dominant as the billing model. When many lawyers or clients talk about alternative fee arrangements, all they are really talking about is discounted hourly rates, maybe with a cap. Wow, that's wild. Lawyers make more money the more hours they spend on something. So in an environment like that, when you come in with an innovation that is going to allow them to do more in less time, their self-interest is going to tell them not so interested in that. And they think that system is just fine. Lawyers in big law firms make a lot of money. I think at Wachtell last year, the average was $5 million per partner. It is, if you're in a big law firm today and your partners aren't averaging 7 figures every year, you got problems. They think the system is working just fine, and they're not getting pushback from their clients to change the pricing model. A fifth impediment to the adoption of technology is law firm structures, the partnership structure, that impedes strong management and quick innovation. Management is dispersed among partners. It's considered bad manners in a partnership for a leader to take control and tell people how things are going to be done. Individual partners in law firms have great discretion about how they manage their transactions and their litigations without centralized control from firm management. A sixth impediment, a malpractice insurance environment that discourages new processes. Insurers rate risk based on experience, based on the past. If you're a law firm dealing with your malpractice insurer and propose to do something significantly different in the way you practice law, you may get significant pushback from your insurer because that's a risk they see that they don't have experience to rate. A seventh impediment. We have, obviously, a legal system that's based on precedent, on what has been blessed before. And this, too, deters the adoption of technology. An example, predictive coding for discovery purposes, automating the review of documents to identify those that are responsive in a litigation. Technology can do that wonderfully. I actually think it can do it better than humans can. But courts regard it as not adequately tested, as too new, and there's still a great debate about whether a lawyer is complying with his or her obligations in the discovery process to use predictive coding to identify the documents that should be produced. And where it is blessed, it's blessed under rigorous court supervision, where the court has to approve often the use of the particular terms that will be used in conducting the search. An eighth impediment, legal education, with only a few exceptions, provides no grounding in management, efficiency, client service, or user focus. How many of you here in this room went to law school? Keep your hands up, please. How many of you got any training in management in law school? There are a few hands, wow. This is part of the practice of law, but it is a component of practice that law schools leave to the profession and don't regard as a part of their education. Every lawyer, the day he or she starts practice, is a manager in one way or another, whether they're managing a paralegal or an assistant, they're managing client relationships. Law schools do really nothing to prepare lawyers for that possibility. And in a service profession, where the focus really should be on serving the client, the service mentality gets addressed in law school incidentally, if at all. It may be addressed as a part of a professional responsibility course, but that's really quite different from the consumer focus that I'm talking about. A ninth impediment. We place a great emphasis in legal education and in practice on lawyerly judgment. We encourage the notion that every case is unique, different. We resist systemization and commoditization. We think that those are antithetical to the principles that should govern good lawyering, and they get in the way of technology that presupposes a different construct. Tenth, part of the problem is at the beginning. Who becomes lawyers? Risk-averse people. People who didn't want to go to business school. There's a very well-known professor at the Wharton School, Adam Grant. He's very prolific. You may have read some of his work. He teaches occasionally at the University of Pennsylvania Law School, where I went. He's been heard to say that the law students at the University of Pennsylvania are smarter than the Wharton students, but they are so risk-averse that it impedes their success. The Wharton students are not risk-averse, they're entrepreneurial, and he thinks that the mindset of the law students interferes with their ability to succeed in serving their clients. Now, I've asked myself, did they come to law school that way, or did law school make them that way? There's room for debate. I think they got there that way, actually. So those are 10 impediments to the adoption of technology. Sorry to start with such a downer, because they're pretty significant. But I think that there are levers of power, agents of change out there that we can enlist to accelerate the pace of change. And most of them are not lawyers. Most of the solutions I propose involve going around the lawyers, in some instances over their heads, to engage people, to compel them to do what they would not do on their own, left to their own devices. My thesis is this: as long as we're trying to improve the pace of adoption using only lawyers and techies, we're not going to make much progress. That's too insular. We have to figure out who outside that network can be brought in to accelerate the change. So here are my 10 agents of change that can be enlisted to improve the situation much more quickly. The first is kind of insider and sounds obvious, but not enough is done with it. Courts and court administrators can be very responsive, particularly when the pitch is put to them as improving access to justice. Judges see what's going on in their courtrooms with huge numbers of unrepresented litigants. It is hard to be a judge presiding over a case where a person does not have a lawyer. It slows things down. It's difficult to accomplish a just result. Judges often feel enormously frustrated at seeing a litigant before them whom they know has a valid claim or defense, but they don't know how to put it on because they're not familiar with the rules of civil procedure or the rules of evidence. And the obligation of the judge to be impartial prevents the judge from intervening to the extent that he or she might like to be able to do. Court systems, court administrators, chief justices of state supreme courts are interested in these issues. They are allies. The Conference of Chief Justices, the organization of the chiefs of the 50 states and the territories, issued a resolution last July urging a goal of providing some form of effective assistance to 100% of persons with an essential civil legal need who are unable to afford a lawyer. And they pointed to technology as a critical way of implementing that goal. There are states that are beginning to pursue a concept that the Legal Services Corporation advocated in a technology summit report that we issued at the end of 2013 to create statewide access portals, a single point of entry, a single point of online entry for anybody seeking assistance with a civil legal need that would route them to the appropriate level of service based on the capacity of the client, the nature of the matter, whether the opponent is represented, what's at stake, would use an algorithm based on constantly updated experience to route people to the appropriate level of service. Courts and court administrators are interested in that. And if you go to the organizations of them, the Conference of State Court Administrators, the Conference of Chief Justices, they can be enlisted in the battle to promote the adoption of technology. A second ally, funders of civil legal services. Let me give you an example. The Florida Bar Foundation administers the state interest on lawyers' trust accounts money. They are the state equivalent of the Legal Services Corporation, making grants to legal aid providers within the state of Florida. They have about 30 grantees. They decided to compel all of their grantees to adopt the same case management system so that there would be uniformity of reporting on legal aid cases across the state, and it allows the funder basically to suck out from all of those case management systems comparable data that allows them to get a good picture of what's going on in the state and to compare one program to another. They picked up the tab for that. They used some of their funding to permit legal aid programs that were not using the system that they wanted adopted to purchase it. And it's done remarkable thing. The Legal Services Corporation has also done a lot with our little budget of $4 million a year to promote the use of technology. Look for other sources of funding, and keep in mind, particularly in the world of access to justice and civil legal aid, it doesn't take a lot of money to cause people to jump really high. I'll give you an example. Last month, we announced at a forum at the White House that Microsoft has pledged to commit at least $1 million and project management and technical support to pilot one of the first access portals that I just described. $1 million. When word of that got out, the community just blew up with people interested in $1 million? How do I get my hands on it? States are willing to do things that they have never done before in systematizing easy access to civil legal services because of the prospect of $1 million. So think about funders, who has money and who might be enlisted to promote adoption. Third, go over the heads of lawyers directly to their clients. Now, this can be hard because the clients are often lawyers themselves, general counsels of corporations. They often grew up in big law firms, and they may be part of the problem. But there are clients out there who are very interested in promoting the use of technology. Jeff Carr at FMC Technology, and you know him, he retired recently as general counsel, was a real leader in promoting the use of technology. He created a technology competency test for lawyers that were going to work on his matters that required that they be able to demonstrate that they knew how to turn a Microsoft Word document into a PDF without scanning it. Pretty radical, huh? He had a good sense of what lawyers can do and can't do, and he had a checklist of things that people needed to be able to demonstrate, just the basic competencies, because he knew that a huge percentage of them couldn't do it if they weren't required to learn it. There are leaders out there, and the best way to engage with them is through organizations like the Association of Corporate Counsel or the much more mysterious Association of General Counsel, which is a group of about 100 general counsel of the biggest U.S. corporations. These are people who control the purse strings of the big lawyers. You need to identify the particular players among that group, those groups. They exist. Focus on them and make them allies. A fourth potential ally. Is there anybody here from American Lawyer Media? Used to be, Monica, okay. Get the American Lawyer to rank law firms based on their use of technology. Publish it. Shame them. The rankings of law firms change behavior. Look at what's happened with the focus on profits per partner. Most people would say that was not a positive change. There's something else that the American Lawyer has done that I think has had a positive effect. It's their A-list of law firms. Their list of 20 law firms that they think lead the pack, not only in terms of their profitability, but in terms of their emphasis on pro bono, diversity, and quality of life for their associates. When the American Lawyer came out with its first A-list in about 2003, I was managing partner of Arnold & Porter. We were number 4 on that list. That was a great source of institutional pride. Other firms took notice. Firms compete to get on that list. I heard the recently retired chairman of Kirkland & Ellis say recently that the A-list caused Kirkland & Ellis to radically ramp up its pro bono program. They are a real leader in pro bono today because he thought that that was critical to getting on and maintaining a high position on the A-list. The only way I see law firm technology being rated in any way today is the American Lawyer survey of mid-level associates that they do annually. And one of their questions asks the associates to rate their firms on technology. And they'll point that out in the article that they write about the survey, but it does not get a lot of emphasis, and it's not terribly scientific. Well, think about who in the legal world, like the American Lawyer, might be prevailed upon to begin to take a close look at who's doing what and to come up with a set of standards to evaluate the tech proficiency of lawyers. Get the legal media to focus on this, even if it isn't rankings, to write stories on who's doing what and who's not doing what. That will get the attention of law firms and cause them to pay attention in a way that they haven't to date. A fifth lever, and I'm going to contradict myself here, don't give up on regulators, including bar examiners. There is a notion, gaining currency in some quarters, that some proficiency with technology is part of competence as a lawyer. There is a legal obligation to provide competent legal service. And if you're not using the appropriate technology to do that well, you're not meeting the standard of care that lawyers should be complying with in meeting their professional obligations. So think about ways in which receptive regulators might be engaged to lead a change that would cause the adoption of tech competency as something that's required to become and remain a lawyer, and maybe even be tested on a bar exam. A sixth lever of change. Think about who pays for legal services who may not be the ultimate client. Insurance companies. This is another example of going over the heads of the lawyers. Insurance companies have had influence on the way the law firms that they pay do their business. They were behind a movement in the 1990s to standardize tasks for billing purposes to make it easier for them to compare the performance of different lawyers. What's it costing a particular law firm to provide a particular service in connection with a litigation? They could do the same thing with technology. They have an interest in efficiency. They do want the work done in less time, not more. So think about approaches to big insurance companies when you're trying to market technological change and how they might be engaged in requiring the law firms they use to adopt. Seventh, and I'm going to contradict myself again, think about malpractice insurers who may be an impediment because they rate risk based on experience, But if you have an innovation that you think is actually going to reduce the risk of malpractice, if you have an innovation where you think the failure to adopt could put a firm at risk, think about how to approach malpractice insurers to make that pitch. Law firms will listen to them. Eighth, notwithstanding what I said about going around lawyers, there are some lawyers who can help, some law firm leaders who get it. If they could be given attention, if you could shine a spotlight on them, give them a platform, you'll give them a competitive advantage that will engage them and amplify their voice. So look for leaders in the legal profession. If you come across law firms that you think are outliers in terms of adoption, make them allies and give them a platform, use them to persuade and shame others. Ninth, this is a longer-term proposition. Legal academia can help by introducing law students to the use of technology at the very beginning of their careers. Make it part of legal education. I see Tanina Rothstein here. I know Ron Stout is here. These are people who in their law schools are integrating technology into the curriculum and doing it in wonderful ways. I guest lecture at Tanina's course each year. Thank you, Tanina. And I'm always impressed. This is a course that requires, during a semester, for the participating students to develop an app. They get the ideas for the apps from different legal aid and public interest organizations that have identified a need that can be met with technology. And during the one semester course, they break up into teams and they have to design an app. What's fascinating to me is that they don't need to code to do this, and most of the people in the class have no background in technology. They're plain vanilla law students. And at the end of the course, they've designed an app. It's an amazing experience. What they have to learn to do is to put themselves in the shoes of the ultimate user of the app, who's often going to be a self-represented person. They have to imagine the client experience, not the lawyer experience, and design an app that's going to be responsive to the user's needs. They often have to learn an area of law that the app is going to affect. It may be eviction cases, for example, or veterans' benefits. And they have to develop the capability to actually design something that functions. And at the end of the course, they demonstrate it before a panel of judges. We need to do more things like that. Now, this is an elective. And I think Tanina might have had 26 people in her course this past semester. It's oversubscribed. 26, this is at Georgetown, where a class is about 600 students. Not enough. We need to do more. We need to integrate training and technology and that user-centered focus into legal education. And finally, and as a former bar president, I'll get in trouble for saying this, think about legislatures. Think about circumventing the lawyer-administered regulatory process. This is a consumer protection issue, I think, the effective functioning of our legal system. It's something in which there should be a very strong governmental interest. Access to justice, equal justice under law, is one of the core principles of the United States. It's about who we are as a country and what we hold ourselves out to the world to be. It's reflected in the very first line of the Constitution. The first line of the Constitution reads, "We, the people of the United States, in order to form a more perfect union, establish justice." I think that's fascinating. The framers cited establishing justice as their goal even before they mentioned providing for the common defense or ensuring domestic tranquility. I don't think their ordering was an accident. I think they recognized that a well-functioning, accessible system of justice is essential to societal stability. It's about the rule of law. You won't long have a nation to defend or worth defending without it. This is what the great Judge Learned Hand meant when he said in addressing the Legal Aid Society of New York in 1951, "If we are to keep our democracy, there must be one commandment: thou shalt not ration justice. Well, if we have technology innovations that can improve access to justice, and if their adoption is being impeded by self-interested regulatory structures administered by lawyers, shame on the lawyers. Go around them. Go to state legislatures and get them to compel what the self-regulators did not do themselves. So that's my list. It includes many people and entities that are not represented in this room. My message is that we need to reach out. Insularity is the enemy of effective movements. No revolution can be successful if it's entirely insular. Think about who you'd like to have at this conference next year and the year after. Think about people from the audiences I mentioned who might be engaged to participate, with whom we can join arms and bring about the revolution that has not occurred yet. I think it's embarrassing that the legal profession lags so many other industries and professions in the adoption of technology to serve our consumers, clients, which is what our profession should be all about. We should be leading the way, not dragged along behind others. We have in this room a group of innovators, entrepreneurs, builders, doers. You can make this happen. Just expand your reach to include others, and I think we can set the world on fire. Thank you very much.
All right, so if you have questions, please come. There's one, Benjamin.
Hi, I've heard and also read claims that 90% of the work that lawyers do in the US is assist their clients in preparing and filing forms. So that's an obvious candidate to automate. How official are such studies? And is there a way to weave that observation in to the 10 levers of change that you were talking about? Or where to weave it in those?
I don't know the basis for that statistic, and so I don't know how valid the observation is. I'm confident that anybody who studied it rigorously could come up, whatever the percentage is, it's going to be impressive. It's going to be a very significant number. So if that's the pitch, I think the starting point would be to get
Maybe it's not 90 and it's 60, but still that's pretty hefty.
That's a really good number. Yes, yeah. You can work with that. But it would be good if that's the pitch, to be able to demonstrate efficiency by starting with a baseline and validating that number, or funding another study that would come up with a good statistic that could show that. But you still got problems like the one I mentioned with different courts in different states using different forms. And you run into resistance to that, not only from judges, but sometimes from lawyers. There was a shameful incident in Texas a few years ago that some of you may have heard about. The state Supreme Court wanted to compel the adoption of user-friendly forms in family law cases for self-represented people to simplify things so that a reasonable person reading the form could figure out what information they needed to provide. Sounds like a very reasonable change. It was opposed by the family law section of the Texas State Bar. They thought they claimed that this was in the interest of consumers, that they were exercising their objection, because they thought this is just going to encourage people to do things on their own. They shouldn't be doing that. They should be going to a lawyer. Well, we're talking about people who can't afford a lawyer. We're talking about the people who are overwhelming the courts as unrepresented litigants. But forms clearly, that in terms of improving efficiency, expediting the process, simplifying the process. That is a critical place to start, and I think it should be a real point of emphasis, and it would be great to have valid data to drive the change.
Yeah, my name is Benjamin Grossoff from Coherent Knowledge. So if anyone wants to tell me like where to find things to follow up on that point, I'd be interested. Thank you.
Yeah, hi, I'm Kriparaj Shekhar from Autonomy Labs. There were three things which you didn't mention in your levers, which I was curious about. Metrics, so what's a good outcome? Not sure if it's easy to solve that problem, but that's one lever. Arbitration, and then litigation finance, or the general sort of financialization of law. I was hoping you could comment on those three levers.
Those are all, I was trying to identify institutional levers rather than processes, but those are all great points. The last one could be people who have money, anybody who's got money, people who finance litigation and have an interest in efficiency are clearly people. I did not mean to suggest my list is exhaustive. I should have started by saying that. I thought 10 would be a nice number on both things. I'm sure you can come up with others. I could come up with others. You may have some that are stronger than the ones that I identified. But I agree with your observation, particularly the process changes like arbitration, like online dispute resolution, things like this are very, very important. But you need the tools in place first, and people willing to adopt those tools before they're going to be effective in making the system more efficient for the ultimate user.
Hi, I'm Ralph Baxter. I'm a fellow here at Codex. First, I want to thank you and congratulate you for your dedication to access to justice and for the clarity with which you describe and share with all of us the underlying issues that lead to the crisis we really are facing. Thank you very much.
Thank you, Ralph. I went to your conference a number of times. The Baxter Fest, we called it.
So one of the institutions that obviously has a huge influence on all of this is the American Bar Association. William Hubbard and others have been trying valiantly to stimulate progress. Recently, it appears the House of Delegates has once again said no to the issue of outside capital to support innovation, as you suggested. So do you have ideas for this audience about how it might influence the American Bar Association?
They're not on my list. It's not an accident. I was there at the House of Delegates meeting in February when they took a vote, not on non-lawyer ownership of law firms and funding, but on another issue that would adopt there was a resolution that proposed a series of mom and apple pie principles to govern the regulation of non-traditional legal services providers. And it passed, but over vigorous opposition, including from the New York State Bar Association and the New Jersey State Bar Association. They thought that it was anathema to recognize the possibility that someone not licensed to practice law might have anything to do with legal services. They thought this was the nose under the camel's tent and it needed to be shut down. I thought it was, I didn't know what century I was living in. It was, so it failed, but I think that, you know, the ABA is a membership organization, and the people who are most active are often active in their local and state bar associations. I love William Hubbard. I'm a big fan of his. I think he has done enormous things to move the ABA along. I think his personal advocacy has been very effective. I'd like to support him, but I personally would, on the issues that I'm talking about, if you're looking for quick adoption of change, they'd be lower down on my list.
But I think if you talk more, I agree with everything you just said. And then 105, that resolution, did in the end, though, have in it very important elements, including
yes.
Referencing access to justice, referencing efficiency, and so on. Mm-hmm. I think the more we talk about the ABA's consideration of these issues, the more we will awaken
Yes.
lawyers to be more active. They get very few responses when they put out these white papers, and the responses come from those who most want to protect the status quo, and I think your voice added to the conversation might be helpful.
Thank you.
Hi, thank you, Jim. Excellent presentation. My name is Rob Ciccone. I'm with Next Law Partners. One simple question for you. Do you think we have too few or too many lawyers in this country to tackle these issues that you described? Or perhaps we need an entirely new breed of legal expert?
I have mixed feelings on the answer. When I look at the extent of unmet need out there, it's hard for me to say we have too few lawyers. But I don't like the approach that lawyers are necessarily the answer. The system is just too complicated. And there are never going to be enough lawyers to provide individual representation to every person who might be navigating the system alone today. It should be a combination of other professionals who are working with lawyers. We should look to the medical profession, the way they brought in nurse practitioners and doctor's assistants and other people, and free up the lawyers to do what only lawyers can and should be doing. I mean, we have a wildly dysfunctional market when you have so many underemployed and unemployed lawyers today and so much unmet need. That's just the classic symptom of a dysfunctional market. So I think we need more lawyers doing different things, assisted by other people.
Thank you.
So
let me just test something a little bit about the ABA and comment. Their model rule 1.1 does inject, a notion of technical competency. The State Bar of California has an opinion on technical competency, and a number of states have picked up on the ABA comment as well, I understand.
thank you. Well, I'd like to conclude by making an offer. If I can be helpful to any of you, count me as an ally. I'm not a techie myself, but I do understand the role of technology in improving the service of clients, and I'll do anything I can to be helpful to you in your efforts. Thank you very much.